Hi, this is a video for homeowners seeking to avoid foreclosure and sale. It's an unusual video because it's proposing to do something different for homeowners because of the way in which homeowners have been treated by various types of people. This is a solution, as I see it, to the problem of what do I do now? I don't understand where we are. What can I do? I don't understand what's happened. So my name, let me give you that, is Carl Pearson, and I'm an attorney spending most of my time in defending against foreclosures, and I'm helping clients throughout the United States. Saving your home from foreclosure and sale may be possible, but it depends on what has happened up to this point. What most homeowners facing foreclosure must determine, if there is anything that can be done, is to have a competent foreclosure defense attorney review all relevant documents and analyze them for the best steps to take at this time to save their homes. Whatever things you, a homeowner, has already done pro se or with the help of a consultant, paralegal, or even an attorney, if not a litigating foreclosure defense attorney, should be reviewed to determine your best course of action, usually litigation, to save your home. And this requires two steps. Step number one is assembling the documents. The cost of getting the documents together may run around $250, that's my estimate, but this is a very valuable thing for you to put together, and the package will be needed by whatever attorney you retain and should result in lower legal costs for you and better legal results. It's truly a bargain. Persons experienced in preparing loan securitization audits or title searches are the best for this purpose, as I see it, and can serve a very valuable role for the homeowner if dedicating themselves to putting together these needed documents. I like to think of this person as a document gatherer, someone who acts as a professional intermediary between the homeowner and the foreclosure defense attorney, in the same way that a claims adjuster is an intermediate between a claimant and an insurance company. Step two, reviewing the documents. Once all the documents have been put together, they should be scanned to create PDF files and emailed to me for review. My charge for this review is $400, which anticipates about 1 1/3 hours of work for me, including a review of each of the documents, making notes on my review, and having a lengthy telephone conversation with the client homeowners to advise them on what steps they should now take to have, in my opinion, the best chance of their saving their home from foreclosure. Generally, I say they should commence some type of litigation, and I explain what type of litigation they need to commence, what steps they need to take. Please remember that there is no guarantee that these next steps will save the homeowner's home. But if the right steps are taken, the homeowner has a statistically better chance of saving his or her home than doing anything else. The next steps are not magic. They become self-evident to an experienced attorney in defending against foreclosures, using litigation against the bank. Others who would give advice without such experience are less able to know what needs to be done. Before going any further, I want to list some of the variables that will make a difference in the outcome for different homeowners, even though their next steps may be the same. 1. The contents and dates of the preceding loan modification applications and the bank's real reasons for denial, which aren't usually disclosed to the homeowner. 2. The competence and experience of the person preparing the loan modification application for the homeowner. 3. Whether the mortgage property is underwater or not, and to what extent. 4. Whether the property is located in a judicial or non-judicial foreclosure state. 5. Whether the homeowner lives in the property and plans to remain living there if granted a workable loan modification agreement. 6. Whether a principal reduction is needed for the loan modification agreement to be affordable. 7. The entity, such as FNMA, that's Fannie Mae, Freddie Mac, a vulture fund, a REMIC trustee, a bank, or individual investor, which claims to own the note and mortgage. 8. The number of months during which the mortgage has not been paid. 9. The income, expenses, assets, and indebtedness of the borrower. 10. the availability of other support for the loan applications, such as tenants, relatives willing to go on the mortgage, government subsidies, tax abatement policy of local government. 11, ability and willingness of the homeowner to put together the needed documents and provide the information needed for review of his or her foreclosure situation. 12, the law firm representing the bank. 13, the availability of the records for your loan, including the original note. 14, whether MERS, the Mortgage Electronic Registration Systems Inc., or MERS Corp Holdings Inc., is involved as a nominee for the owner of the mortgage. 15, differences in appraisal of the property. 16, the homeowner's credit score. 17, other documents that may come to mind, including notes of conversations in trying to obtain a loan modification agreement. Review of the homeowner's situation by a competent foreclosure defense attorney for a small reviewing fee is preferable to paying much larger sums of money for help in preparing a loan mod application, or paying an attorney who's going to push you into bankruptcy or a short sale, or has no idea on how to conduct foreclosure defense litigation. In a lawsuit, if you start off with a wrong approach in your complaint or answer, you may not be able to recover and will probably lose your home as a result. Litigation requires that you start off with the right documents from the beginning. The review will also point out where you may have an opportunity to improve upon prior litigation documents to make them more threatening to the bank. The documents needed for my review. I need to review the following documents to be able to understand what you need to do at this present stage of your foreclosure problem. And litigation documents. Copies of all documents filed in each lawsuit relating to the property, if there has been any lawsuits. The list of all documents filed in each of those lawsuits. All lawsuit discovery obtained or provided. Copies of all decisions in each of the lawsuits. 2, loan closing documents. The deed for the property, the note for each loan, the mortgage or deed of trust for each loan, a closing statement for each loan. 3, the county clerk's office. Copies of all mortgages, assignments, satisfactions, lease pendants filed against the property. 4, bankruptcies. A docket sheet for any bankruptcies during the past, say, 5 years for any of the mortgagors or note makers. 6, notices from the bank. A copy of all notices of default or notices to cure from the bank. A copy of all offers from the bank, such as short sales or deeds in lieu of foreclosure. 7, securitization documents. SEC documents showing the claimed owner of the note, the Bloomberg terminal type information, the pooling and servicing agreement, the underwriting agreement, the bill of sale, and the trust indenture agreement. And loan modification documents. All loan modification and forbearance applications made by you as to any of the loans and any correspondence from the bank concerning such applications. Now that's a lot of documents to review and a lot of documents to put together. You need that. That is a package that is your problem. Your problem is in that package, and an attorney needs to see the whole thing to determine what you need to do next. So with these documents, I'm in a position to determine the steps you should be taking to keep your home if it's possible. These steps might include a motion to vacate a default judgment, or a quiet title action, or a summons and complaint and motion to vacate a sale or eviction order, or an adversary proceeding in a bankruptcy proceeding. All of the described documents are necessary to enable me to decide the best course of action to save your home and to give you an idea of the feasibility of such a proposed course of action. Doing the right thing doesn't always enable you to win. The further along one goes on the path towards foreclosure, the more difficult it will be generally to stop the process. But litigation should be considered at any stage in the foreclosure process and is generally most effective starting from the very beginning, but it also can save your home when used later down the foreclosure path. As the attorney for homeowners, I give my best legal judgment to them on what can be expected from the litigation steps that I outline for them. The total cost of $400, that's my fee, plus $250 to a person that gathers the documents, a total of $650, is a reasonable price for learning what, if anything, you can do in light of all that has occurred to you up to this point. If you have any questions, please send me an email with a single phrase "document review" in the subject part of the email, and include your name, state, and telephone numbers so I can give you a call and talk about your problem, and do so at no charge. My telephone number is 212-307-4444. Thank you.